Welcome to the Spiggle Law Firm podcast, where we help people who've been fired or afraid that they might be, and we discuss cutting edge legal issues in the news. I'm Tom Spiggle, founder of the Spiggle Law Firm, and I'm thrilled today to be joined by an attorney in my office. His name is Ross Fodera. Thrilled to have you with us today, Ross. I think we're going to be talking about sovereign immunity, the exciting topic of sovereign immunity. But before we jump into that, a little bit of legalese here for our listeners. This is not intended to be legal advice for your specific case, and it doesn't create an attorney-client relationship with our firm. If you want both of those things, then you got it. You should go hire a lawyer. So with that, Ross, I know you want to talk about a specific case today, so let's dive right in.
Yeah, so this case arises out of the 11th Circuit. It's called Dupree versus Owens in Georgia's Department of Human Services. Essentially, it's a consolidated case between two plaintiffs. First is Jennifer Dupree, who was working for the Georgia Department of Human Services when she requested some reasonable accommodations to adjust her schedule to get to some medical appointments. And then essentially they called her doctor, and there was a big misunderstanding over whether she was disabled, and that led to her termination. And then the second plaintiff is Mr. Battle. He works for the Department of Corrections in Georgia, and he had a similar case where he was hurt on the job and was terminated since he was not sending in certain medical documentation. However, he claims that he was terminated before the documents were even due. So they both brought Title I ADA claims and Title V ADA claims, essentially alleging employment discrimination based off their disabilities and retaliation. And the district court held that they were barred by sovereign immunity from bringing their claims because it was relying on Title I, and the 11th Circuit affirmed. The plaintiffs attempted to argue that the Supreme Court's decision in Tennessee v. Lane applied, as that case held that Title II ADA claims were not barred by sovereign immunity. However, those claims deal with the administration of programs and things of that nature rather than employment issues.
Yeah, no, it's a fascinating topic. And for those of you who are listening who aren't burdened by having a law degree, do you want to talk a little bit about what sovereign immunity is?
Mm-hmm. Yeah, so under the 11th Amendment of the Constitution, essentially the federal government allowed states to enjoy a certain protection from lawsuits. And when Congress makes a law, they have to very intentionally write it to say that states are able to be sued under that law. Otherwise, it will be held by the courts they just don't have jurisdiction over it. And that was actually a big part of this case was the plaintiffs argued that the dismissal of the district court wasn't specified whether it was with or without prejudice. So they spent a good amount of time trying to get that determination that it should be without prejudice since it's a jurisdictional decision and not on the merits. So hopefully they'll get another route to be in court, and the case was remanded back to make that determination.
Yeah. So I think it's important for folks to know that sovereign immunity only applies to government entities, right? Like, as you said, particularly with the federal government and also with some state government issues. Basically, sovereign immunity was that you can't sue the king, right? That's the going way back version of what that means. But the king basically had to grant citizens right to sue him or her, mostly him. And so that sort of thought or that principle, carried forward to our government, where if you're the federal government, state governments have to give you, the citizens, the right to sue them. Otherwise, they have sovereign immunity. The king has immunity. And the government has done that on many occasions. So there are many ways that obviously we see this every day where citizens bring claims against the any kind of government entity. But if you're suing, some Fortune 500 company in the private sector, sovereign immunity is not going to apply. It's only as to government entities. And it's a complicated doctrine. This is not something that as a, going pro se or going without a lawyer, you can't go to Chat GPT and punch this one in and try to get figure out how sovereign immunity works. So they tend to be very complicated claims, as you just kind of raised here. They're dealing with different titles of the Americans with Disabilities Act and whether or not, the state in this case had waived its sovereign immunity, and they found that it had not. And this doctrine is sort of like Swiss cheese. I mean, it doesn't sometimes make a whole lot of intuitive sense. For some laws, the government has waived its immunity, and for some, it has not. So it's an interesting topic, but if you're private sector, this is not something that's going to affect you. Another thing that you raised, which I think is an important concept for people to know, what does it mean when you say with or without prejudice?
Mm-hmm. So if a claim is dismissed by the court with prejudice, essentially you're not allowed to bring that claim back into court. The judge is basically saying, you had your day in court, we heard all the facts, and we've made a determination. Whereas without prejudice is usually given when there is a jurisdictional issue, when they tell you you're in the wrong court, or you didn't state the right kind of claim and things of that nature. And it essentially allows them to try other routes to get the same claim back into court.
Yeah, exactly right. This does apply to all kinds of cases, not just sovereign immunity. And we see it quite a bit, particularly when we get when we have one of our clients, sometimes when they have filed on their own, the court will dismiss their complaint, as you say, because they failed to allege the right facts or failed to state a claim, but they'll do it without prejudice, which means, okay, you get a do-over in this case. Plaintiff, you can go back and take another run at this. And that's not terribly uncommon. We had clients before who have filed their own, even some of the complaints that we filed, the court has disagreed or found you didn't think that we state a claim. And they usually will, the issues that come up during oral argument kind of give you breadcrumbs as to, what the court thinks needs to be alleged in order to state the claim. And then you get to, the court will say in its opinion that it is without prejudice, and you can get another bite at the apple. If it is with prejudice, then you're done. The case is over. At summary judgment stage, those decisions are almost always with prejudice. So if you lose at the summary judgment stage or have claims knocked out, those are with prejudice, and game over for those particular claims or for the case in general. So yeah, that is an important concept that applies to all kinds of cases.
And another thing I wanted to add was the fact that this applies mainly to states creates other interesting possibilities for the future. This was in the 11th Circuit, but there's similar decisions that have been held in the 5th and 9th. Here locally, a lot of people would not expect this, but WMATA, the Washington Metro Authority, enjoys sovereign immunity since they're a compact between D.C., Virginia, and Maryland. And it'll be interesting to see if as these cases eventually reach the Supreme Court and we get a national standard around ADA sovereign immunity, it'll be interesting to see if these arguments are applied to kind of more quasi private public sector jobs and federal state, as DC is funded by the federal government. So it'll be interesting to see if they'll make certain arguments that DC acts more like a state than the federal government to get into that sovereign immunity.
It's a great point. Like what we say is a circuit split, right? Like we've got some circuits that have either not ruled on it or ruled in a different way. And just so folks know, the country is divided up into different circuits. So there'll be a number of states in one circuit. So in our area, for DC, Maryland, and Virginia, we are in the 4th Circuit. This case was a Georgia case, right? Was it Alabama? I can't remember. Anyway, yeah. And that's 11th Circuit, 9th Circuit. We on the West Coast, so we have these various circuits. And the appellate courts within those circuits hear cases, and sometimes they can come out with different holdings on similar issues. And that's those are the kind of cases that the Supreme Court will take up, because then the Supreme Court has to kind of play referee and say, okay, we can't have, we can't have on this topic, whatever it is, in this case, ADA, retaliation, sovereign immunity. We can't have it existing in the 4th Circuit and not existing in the 11th Circuit. So you're right. It'll be interesting to see. That'll probably end up in the lap of the Supreme Court and how they deal with it, and what kind of contours they put around this issue of sovereign immunity, because it's a big deal. I mean, this would mean that plaintiffs with these claims, like retaliation claims under the ADA, we see that not infrequently, they can be knocked out of court completely, or the Supreme Court could say, no, Congress has waived its sovereign immunity, or these principles don't apply to these state governments, and in which case, you would have access to the courts. One thing that we talked about to even complicate this further, before we were on the podcast, there is something called the Rehabilitation Act, which acts like the ADA that applies to the federal government, and that's a whole different law. Whole different issue about retaliation. So when you're suing government entities, it can get really, really sticky and really complicated quickly. It does help, particularly in these kind of cases, to have a lawyer to kind of help you navigate these waters. Well, it's a great topic. Anything else you want to cover on this, Ross?
I think that's all I got for today.
Okay, that's a good one. Just remember sovereign immunity. You gotta watch out for it if you're suing a government entity. Go talk to a lawyer if you're in the private sector. Not something you got to worry about. But great topic, and I will let you get back to the next thing on your desk, Ross.
Great. Thank you.
All right, take care. If you found this episode helpful, feel free to forward it to a family member or a friend. We're trying to help as many people as we can understand their employment law rights. And also, if you would like more information like this in your email inbox, go to our site, thecareerrocket.io, and you can give us your email, and you will, for free, every week get an email from us with the latest and greatest in employment law. And not only that, but other tips and tricks on how to keep your career on an upward trajectory. For instance, how to draft a killer resume, how best to interview, similar tactics for keeping you in the best position possible with your career. Take care out there. I hope this helps. And until next time, this is Tom Spiggle.